Today I will be discussing employee privacy, focusing on the monitoring of email and telephone conversations, as well as drug testing. I will discuss the legalities of these topics and the way employers view email and telephone usage, as well as how drug testing is conducted. In many workplace settings, employers will monitor employee email. In a 2007 survey conducted by the American Management Association, it was revealed that out of the companies surveyed, 43% monitor employee email, 28% have fired an employee over email misuse, and 15% have faced a lawsuit related to email monitoring. This brings up whether or not it is legal to monitor email. In most cases, it is legal for employers to monitor email. Oftentimes, you will be asked to sign an agreement allowing this upon hire. As long as the company has a valid business purpose, such as confidentiality or productivity of employees, emails may be monitored on a company email account. If emails are sent from a personal email account or on a personal device, a waiver would have to be signed allowing employers to view them. If the emails are being viewed or sent on company property, such as a computer, laptop, or phone, employers would be able to view them. There are a few different ways companies monitor email. A few ways are a software system being put on a device to copy all messages being sent. Backup copies of all messages are made when employees receive or send an email, and a keylogger software that monitors more in depth. This software can even monitor drafts. Another way employees are monitored is through telephone conversations. One reason companies monitor conversations is for quality assurance. This is allowed as long as it takes place on a company device. Conversations can be monitored by putting apps on devices, tracking texts, phone calls, and emails. Conversations can't be monitored on personal devices without employee consent. Today, many people are starting to combine their work and personal devices, making it less clear whether they are allowed to be monitored by employers. Next, I'm going to talk about drug testing. Many employers require drug testing before being hired, as well as to submit through random drug testing throughout employment. Although employers can drug test, typically the results are considered confidential unless dealing with a workers' compensation or criminal matter. The drug test can only be given for substances disclosed to the employee prior to the test. Usually, tests are only reported as a pass or fail, meaning employers cannot see what substance came up as positive. Some ways employees can be tested is through saliva swabs, blood tests, urine tests, and testing the hair follicles. The most popular ways are through saliva swabs and urine tests. If a drug test has failed, there can be several different consequences. If a test is a pre-hire test, it can keep you from being employed with the company. If already employed, you could face termination or be required to attend a rehabilitation program before retesting. If fired for drug use, you may still be eligible for unemployment since drug abuse is seen as a disability in some states. There were a few topics related to employee privacy that I have discussed and what is allowed to be monitored. As technology and laws regarding drug use change, the way these are monitored will continue to change as well. Here are the sources I used for my research on the presentation. Thank you.